So here's one for you. I'm a estate planning attorney and strategist, Paul Rabelais. I help our clients throughout the great state of Louisiana get and keep their estate legal affairs in order. If I've been asked once, I've been asked a million times. Paul, what does it mean, this provision in the will that says this bequest is subject to the suspensive condition that blah, 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 blah. So, or in a little bit less complex terms, Paul, what's this survivorship clause mean in the will? So I'll tell you what it means. It means it's the question that we get asked often, but rarely is applicable, and it confuses everybody. So I'll try to see if I can set the record straight. So what's a survivorship clause? What does it mean when a bequest is subject to a suspensive condition? So let me back up, give you some background, then we'll lay it all out for you. So what you can't do in your will, at least in Louisiana, and I think most states are similar, is say, I leave and plug in the asset, a home, $100,000, X shares of stock. I leave an asset to A with I leave ownership of asset to A with the requirement that when A dies, it goes to B. Can't do that. Can do some things with trust to have the same effect, but you just can't leave ownership, full ownership to someone with that requirement that it go to someone else when that someone dies. Can't do it. It's called a prohibited substitution. But what you can do is you can say, I leave whatever asset to A and impose what's called a suspensive condition that A survive you for a period of up to 6 months after you die. So why would somebody do that? Well, somebody might say, I want my house to go to Fred, but if Fred dies 1 month after me, I don't want my house to go to Fred's heirs. I want to control who gets my house. So that's what this is all about. You could say, I leave my house to Fred under the suspensive condition that Fred survive me for 6 months. You could say a shorter period, but the maximum period you could say is 6 months. Many years ago, it used to be 90 days. Now it's 6 months. So that way, if you have that provision and that suspensive condition in your will, you die, Fred dies a month later, then the house doesn't go to Fred's heirs, it goes wherever your will directs, as if Fred died before you. So that's the gist of it. Is it a good thing? It can be. Does it apply often? No. Does it oftentimes hold up the succession and keep the kind of property and bequest kind of tied up in the succession? Yeah, it can do that, because if you leave property to Fred under the suspensive condition that he survives you for 6 months, then really he can't own it for 6 months. So it holds up the succession or the probate or the trust settlement until that, that time period is up. So that's one of the negatives of imposing that suspensive condition of someone surviving you for a period of up to 6 months. Can't do it longer than 6 months. So just keep that in mind. It's not something that people often bring up to me when they're discussing leaving their estate. But we see it in just a lot of the generic will forms. So people bring in wills to me and they're like, what's this all about, Paul? So it's a commonly asked about provision, not so commonly applicable, but hope this video helps you understand what this survivorship clause is, what it's often referred to, a bequest under a suspensive condition that someone survive you for up to 6 months. That's what this is all about. Hope that helps. Now go out and get your legal affairs in order, overcome that procrastination. It can really help you and your family. Have a great day. See ya.